So this part of the program, we're talking about a change to the residential real estate closing customs. I'm sure all of you saw the video that Andrew and I did with Susie last week. I just want to give you some history on that because there seems to be some confusion. First of all, Andrew and I have two roles. Obviously, in this role, we're counsel to ECAR. We also are members of the New London County Real Estate Committee, and I'm chairman of that. Andrew is a huge contributor. And we meet as a group. There's about 58 of us who are on the committee. They're lawyers that do most of the closings in New London County, if you were to see the list. And we meet regularly to discuss issues associated with closings, how they're being handled in our county. We originally drafted back in 2000 or August of 2000, the original closing customs. Me and Toby drafted them, and then the rest of the people that were involved in the committee approved them. And there have been various changes throughout the years to address issues that have changed. One of the issues that came up over the past year in two or three meetings that we had is the issue of occupancy at closing and how that's defined and how that's handled. And believe it or not, it wasn't even Andrew or I that brought up the issue. It was another attorney on the call. And ultimately, what it came down to is that we as a county are, or had been, different than every other county in the state of Connecticut. So every other county in the state of Connecticut, the way things work is funds are delivered unconditionally. And when that happens, once the funds are in the possession of the seller and they're free to be used by the seller, then occupancy is granted by the seller to the buyer, and keys are delivered. Now, I'm not talking about what happens in real life, whether the agent who does the walkthrough hands the keys to the buyer. That's not what I'm talking about. What I'm talking about is what the understanding is between all the parties as to when occupancy is permitted. And in every other county in the state of Connecticut, occupancy is permitted once unconditional delivery of funds takes place. It's no different than any other industry in the world, where you pay and then you get your car, or you pay and then they deliver your washing machine. It's no different than that as it relates to closings in every area of the state except New London or New London County. And the reason that was is it was more of an informal agreement among everybody who did work here. And the difficulty that it provoked with respect to the delivery of funds as we're handling them now is that now, as most of you know, closings have been changed. And some of this will be rectified as COVID gets toward the end, but some of it will not. For example, when COVID hit, it was decided that everybody wanted to be as separate as possible, right? You don't want to be in a group with a lot of people in a room. So we separated the closings. Now, many attorneys, many who did a lot of closings were doing this already. But so the seller would come into our office and sign their documents, and that could be done at any time prior to the closing. And then the buyer ultimately would meet with their attorney in their office. And what would happen is the seller's attorney would deliver documents to them. And as long as they had the documents on the closing day, the closing took place. Delivery of funds was then handled differently. So what used to be a very check-intensive system where we'd sit at the table and everybody would be handed checks became a wire-heavy system, so that most funds now are delivered via wire. We, as seller's attorney, deliver documents to the buyer's attorney. Buyer's attorney performs the closing, does whatever they have to do in order to get funding authorization from their lender. That includes sending documents back to the lender and having the lender say, okay, you have our money now, but you can't spend it until we've had an opportunity to review these documents. They review the documents, they get approval. It's called funding approval. And once funding approval is granted, the funds can be delivered unconditionally, right? They can be delivered to the other side unconditionally. And the way that's done now is that's done by wire almost all the time. There are some attorneys who don't feel comfortable with wires and they are still delivering checks, but they have to send a courier to the seller's attorney's office to deliver the checks. And at that time, theoretically, the funds are good. The difficulty in this process is that some attorneys are better at delivering funds than others. And when I'm representing a seller, it is a very difficult conversation to have that, yeah, I understand that your buyer is living in your house and has been doing so for the last day or two, but you still don't have your money. And there's absolutely no reason why that conversation should ever take place, because in no other industry and in no other part of the state does occupancy get delivered before funds are in the hands of the seller. So we had 2 meetings as the bank bar committee discussing this issue. The first meeting we had was in late March.
Yeah, February or March.
Yes, and there was a unanimous vote of like 28 of us to change the custom. There was a few attorneys who didn't realize that we were going to be discussing this at the meeting. So we scheduled another meeting for April 6th, and an extra, I think 8 attorneys joined that call. There were some that couldn't make it from previous calls. And again, while the debate was significant, okay, there was one attorney who voted against the change in custom. So you're talking of the 50 members, probably 37 or 38 of them attended the meeting, and one of them voted not to change the customs the way they've been changed. So let me just show you what that change involves. There were a couple of changes. And let me say, and I apologize, but let me say one other thing. So the other changes that took place when COVID hit is that you guys were banished from the closing table. And, you know, I've talked to hundreds of realtors over the past year. Some of them are really happy that they're banished because it gives them an excuse not to show up at the closing and spend that 2 hours. You know, they've made arrangements to meet their clients at the house and hand them the keys or whatever they've done to finalize the transaction with them and their client. Other agents are still unhappy with the fact that, you know, they don't get to share that last moment with their clients. I don't know, I can't make decisions for other attorneys. Once COVID is over and gatherings are back in place, I will have no issue with a realtor showing up for the signing that's taking place with their clients. Having said that, it will, and again, I can't speak for other attorneys, although I can speak for a lot of them. The process of closing loans has changed. Sellers will be meeting with their attorneys prior to closing in most cases. Buyers will be meeting with their attorneys at the closing table on the closing day and going over closing documents. It has become an incredibly efficient way of doing business, not just for the attorneys, but also for the clients, because there is no distraction in the room. There aren't people talking at one end of the table about one thing, one set of documents, another set of people, the realtors or maybe even the lender, discussing what's going on in their lives because they're not participating directly in the transaction. And then me meeting with my client at the other end of the table and going over documents and trying to talk loud enough so that they can hear, but not loud enough so that it offends the people at the other end of the table. The fact of the matter is that the clients get a very, very personal experience with their attorney, and they get plenty of opportunity to answer questions. What also has changed, at least in my office, and again, I can't talk for others, is we work very hard to make sure that the clients get copies of all documents that they're going to be asked to sign prior to closing, and they have an opportunity to review them and ask questions. So my point being that when I'm meeting with the seller to sign documents prior to closing, I will have no issue at all once COVID is over with realtors coming to the table and meeting with their clients. They won't meet with the other realtor. They won't meet with the buyers if I'm the seller's counsel, but they will have an opportunity to sit down and talk and, well, participate in the signing of the documents that are necessary in order to effectuate the closing. So let me get to
John, if I can
go
just
ahead.
jump in right there for a second, because I'm glad you brought that up. I think a lot of the feedback we got from our initial video, people were concerned about attending closings, and we did not make any changes to the closing custom saying that agents and brokers can't come to closings. That's just been a COVID thing for me personally at my office. I'm at the point being fully vaccinated. It's just me. If agents want to come to closings, they're more than welcome to come to closings. That wasn't something that the committee changed when the change you're about to discuss in more detail had nothing to do with that issue. That was more of a COVID related issue. And I would also like to agree with you that I think the split closings, my clients leave with a better understanding of what just happened. There's a lot going on under the old system of doing it, and you can see by the look in their face that they have no idea what's going on because there's so much distraction in the room. But both buyers and sellers, I feel they leave with a much better understanding of what happened in the process, and they feel more comfortable with questions. They feel more comfortable to ask questions because there's nobody else there. And I think it's easier to address issues as they come up. So not only is it more efficient for us from a business standpoint, because we are a business, but I also think it's more efficient, more productive from a attorney-client relationship standpoint, having just that time to get it done with your client. I think that is one of the better things that has come out of the change to go to the split closings.
It's funny because I think that I agree with you 100%, especially as it relates to buyers. I think sellers realize that when they're in the room and they're signing 7 documents and now they can be done in 15 minutes, there's really not a whole lot to the sale part of things from our perspective,
right? At
least as it relates to between attorney and client. But I think the buyers get a way better experience.
Yes.
I think that the anxiety that exists when they're in a room with 8 other people asking questions that might seem really stupid in their head, when they're just sitting there with me, I feel like it's better. But that's, everybody else can make their own judgments as far as that. That's just my personal opinion. So
go
ahead.
There's just a question here about kind of on this topic. Sellers are pre-signing. When should buyers do a walkthrough? So you're still gonna use whatever time the buyer's attorney schedules with the buyer. That's the quote unquote closing time. So that's when you should schedule walkthroughs in relation to that event. I know John's one of the earlier ones to start doing this when COVID hit, but I mean, the seller could come in 2 or 3 weeks before the closing and sign everything, and has no bearing on walkthroughs or inspections or anything like that. So as far as walkthroughs, that really won't change. You're just going to use the buyer's scheduled date and time as the closing date and back off from there to put your walkthrough time together. Sorry, I just saw that pop up on the chat there.
No, it's fine. It's not showing up on mine. So the first thing that we changed is it's Article 5 or Section 5, which just talks about the fact that, it's not required that we all get together in a room in order to have a closing. You know, we used to be called, we're called a table funding state. And the reason we're called that is because the transaction happens not in escrow. You know, other areas of the country have different procedures. So you'll notice on some of those TV shows where people buy houses that, you know, the realtor meets with the client. It's all a big picture event, right? Where they meet with the client out front of the house, they hand them the keys, congratulations. Well, that's not just, that is true as to how that used to be handled out there, and it's still handled today, because what happens in escrow states is that the one entity, a title company, handles the transaction. The seller comes in at one point and signs their documents. The buyer comes in and signs their documents. The escrow agent, similar to the paralegals that we have, put the deal together, get it recorded. Once it's recorded, then everything's released. And then, so it comes out of escrow. And once it's out of escrow, the realtor meets with the buyer, hands them the keys, congratulations. We've been doing that at the table. And in fact, we're going to continue to do it at the table, but it's just more of a virtual table than an actual table. So paragraph 6 or paragraph 5 says that the process of conducting the closing does not require attendance at the buyer's attorney's office. All documents necessary for the conveyance are to be delivered to the buyer's attorney on or before the agreed upon closing date, with escrow instructions agreed upon by the parties. And that's relevant too, because the change that we made in paragraph number 11 can be modified by agreement of the parties. So this is the part of the customs that's had the significant change, and it's right here. There's also some stuff here, but mostly the first sentence: until such time as the seller's funds have been delivered and received by seller's counsel, and any payoffs wired to the appropriate payoff lender, occupancy by buyers of the dwelling subject to the sale shall not be allowed. Occupancy shall be allowed upon receipt of funds and proof of wires, if any. It is also acknowledged and agreed that unless funds are available to sellers, buyer's counsel shall not record the deed of conveyance. There is nothing in this that prevents the parties from changing that agreement, so that if Andrew and I were working on a deal and I had fun, and I'm just going to throw out a circumstance. I have funds, but it's 5 o'clock at night, and for some reason we couldn't effectuate a wire that Andrew would receive. He may, under those circumstances, agree to allow my client in, maybe because he trusts me, and I have funds, right? I have my buyer's funds, I have the seller's funds with permission to use them, so that there's nothing stopping me from wiring other than the fact that it's 5 o'clock on a Friday. Now, the Fed wire time has been changed. It's now 6:30. So there are banks out there that permit wires to be placed by 6:30 at night. Whether they will be received and credited to the other account is a totally different issue. That depends on the recipient bank. I'm sure many of you have dealt with wires before and understand how they move and how sometimes they're delayed, because there are situations where I wire to someone and that wire is delayed through no fault of mine, through no fault of theirs, because the wire system involves a federal review on each wire, and there are names, for example, that pop up. So if I'm sending to Andrew's client, his client proceeds, and his name is tagged on a federal watch list, that wire could be delayed while the bank ensures that the wire is going to the right place. The bottom line is that we get back to the same issue, and that is, should the buyer be entitled to occupancy when the seller doesn't have their money? And the contract is clear, right? The contract says in one section that funds are to be delivered at closing, And then in another section says occupancy is to be delivered at closing. Those are conditions. The delivery of funds is a condition precedent to possession. And there's no reason why our default position in New London County should be that, hey, occupancy is okay. Let them in. They can live there for the weekend. We hope we get our money on Monday. If we don't get our money on Monday, we'll get it on Tuesday. And if we don't get it on Tuesday, we'll probably get it on Wednesday. You know, that's not, there's no reason to have to explain that to a seller. So I don't know, Andrew, if you have anything that I might have missed.
No, and I think one of the when this first came up at our bank bar meeting, everyone focused on the buyer and the stress and trouble this could cause the buyer who's going to close at 4 o'clock on a Friday afternoon, not be able to get in on Monday. But we represent both sides of transactions, as do agents and brokers. And the seller, we had several attorneys who had dealt with issues. I had a seller myself who 3 days after closing, I'm calling the other attorney every half an hour, where is the wire? And at the time when we were deep in COVID, it's gotten a little bit better. Even if something went wrong and we had to evict that buyer, we would never be able to get them out under the current circumstances. So the safest thing to do, and it's not only, John kept saying the rest of the state of Connecticut, it's practically the rest of the country. You don't buy a car and be like, I'll give you the money on Monday and drive off on Friday. And John did have in the past a situation where late Friday afternoon closing, we allowed occupancy. And on Monday morning, he gets a call from his buyer saying, don't record, I don't want this place. So now it really does, we like to play out the worst case scenario. That's kind of what we aim to protect from. Now, granted, it doesn't happen very often, but the safest way to do this is to make this change. And like John just said, if he calls me up and says, hey, look, I got the money, I'm funded, I just can't get the wire out in time, I will talk to my sellers and say, look, let them in, you're good. But you got to do that on a case-by-case basis. And the safest way to handle that is to have the default provision that is in line with what the contract says already. We don't have to make any changes to the contract. Really, we've been deviating from the contract all these years, and in line with the rest of the state. And the one piece of advice I would give is try and stay away from loading up all of your closings for Fridays at the end of the month, because that's when it's going to be an issue. The end of April, I know John's office, my office, was one of the higher volume month ends we've had in a very long time, and that's where it's going to be an issue, because really funds should be able to be delivered within the next day. And so if you're dealing with a Friday, it'll be available on Monday. And if you're told you're going to have a Friday afternoon closing at 4 o'clock, don't wait till 3:30 to call us up and say, hey, well, the buyer's already got a moving truck. Get out in front of it, reach out, and then depending on who the players are, the parties can agree to allow occupancy ahead of time.
There was a question about 6:30, what time zone?
Our
For
time
us,
zone.
it's Eastern, our time zone.
It's each time zone. It's every
Yeah.
time zone. So whatever time zone you're in.
So we've got a
But,
few
let me-
questions going on, guys. So we'll take them one at a time. And Brian McCarthy has a comment. Brian, rather than reading it, why don't you go ahead and explain your circumstance and ask your question?
Sure.
And then
Well, a
Leanne.
couple things. Number one, I'm primarily Talon County and Windham County, so I very rarely track into New London County. I'm not in total agreement that you guys are the only one doing it this particular way. I've really never left a closing, whether it's completely funded or not, without a buyer client, regardless of which side I'm on, moving into the property, taking delivery of the keys that day, whether the property's been funded or not. The only thing that I've been told is, hey, Brian, whatever you do, don't put the commission check in the bank because we don't have the wire transfer yet. So that's personally what I find to be more routine. That being said, I don't do as many transactions individually as I used to. One of the challenges with the change, the first and biggest, and still continuing to this day, and I guess since it's not New London County, because I'm not talking New London County, is that a fair amount of the attorney's communication back and forth. Like Andrew said, he's waiting for the attorney to say, hey, this has been funded or whatever. We have sellers that, never hear back from their attorney, or we have to track the attorney down. Hey, what happened? Did you get delivery of the funds, etc.? So enough comments about that. But the 6:30 time zone, and I've got other questions, but I'll yield to them. I think that's what I covered basically in what I said.
Brian, one thing about the other counties, and John, you can correct me if I'm wrong, but I think their closing customs do say no possession until funds, but in reality, they allow it to happen.
Right.
But so when we say we're doing what the rest of the state says, we've just made the default provision the same as the rest of the state. That doesn't mean the parties can't agree otherwise. Got it.
So this agreement that this document that we're looking at right now, that's available to the agent base for review.
Yep. So that is available on the ECAR website. It's also referenced in our ECAR contract. And most contracts say, because if you look at this document, it's 25 pages. If we had to put all this information into a contract, that's how long the contract would be. So
Right.
Most any board or corporate forms make a reference to that the closing shall occur in accordance with the closing customs in the county in which the property is located. So each county has these documents, and I know John sent Susie an updated version of these that are available on the ECAR website. And just by way of background, this is where we get the answers for how we're going to handle payoffs, how we're going to do oil adjustments, it's not just this topic. And so when you go to a closing, we're not making all this stuff up. We sit down and agree and make changes over time, but it is available on the ECAR website.
Yeah.
And the question was asked before we go to you, Leanne. Does the contract need to be changed on the paragraph 5 on closing, which says seller shall deliver to buyer a good and sufficient warrant or blank deed conveying marketable title on or before blank closing date? And John's answer was no, that does not need to be changed. Leanne, go ahead with your statement.
I was just saying that I put in a thing saying that if your bank decided that they liked the efficiency of the drive-up, and so they had a meeting and they said, well, we're not opening the inside anymore, you can drive up for your service. I don't think anybody would be very happy with that. And what bothers me about what's happening here is that we have no input at the time that you're deciding these things. And I think you're forgetting a lot of things are tradition. You know, there's probably not many realtors as old as me, but we fought to be able to go into the closings. When I came into this business, you couldn't go to the closings. And we fought to be part of that because it was our customers. And now you're making these decisions and the input is coming after you've made the decision. It's not the right way to do it. I think that the Friday closings came back when it was very important to be able to keep every penny that you could down because of the circumstances. So everybody wanted to close at the end of the month. Educate the agents to the fact that you don't have to do that anymore. You know, that's just a carryover. You're not addressing that. But I think that the process for this was wrong. And if I'm working with somebody, I know them. The attorneys do not know them. So you think you can be efficient with that closing? Well, you're only going to end up getting on the phone and asking the agent the answer to a question because you don't know. You meet with them one time. And who do you turn to when they have a question? So I'm not at all pleased with how this was done. I'm not pleased with the fact that I know that a lot of attorneys, especially if you represent the seller, you're never going to know when the seller goes to sign the papers. The way they're doing it now, you find out later. Your seller calls you and says, oh yeah, I signed the papers. Really? When was that? How do you
Leanne,
fix that
there's
relationship?
once once COVID is over and everybody feels comfortable getting back together, there's no doubt that, at least, like I said, I can't tell you what every other attorney is going to do, but I know Andrew feels the same way I do, is that this was not intended in any way to exclude the agents from anything. The only thing it was intended to do was address the issue of occupancy at closing. And then in terms of the way things have played out with respect to the handling of closings, you'll be able to be with your client at the time that they execute documents, if it's something that you can swing. And the way you'll learn about it is that you'll learn it from the paralegal that's handling the file the same way that you have in the past. If you're uncomfortable,
Jonathan, I'll just go back to my point.
Mhm.
You sit there with your group and you make decisions that are telling us what we're going to do.
no,
I'm going to say again.
Leanne,
not correct.
I want to jump in here, because we did not make any decisions about you coming or not coming to closing. That was nothing we voted on. That is purely a COVID related thing. The only thing our committee voted on was how we're going to handle funding.
Well, that's not
The
the
rest of it-
presentation you put out at the beginning. I'll go back and watch it again, but after I watched it 2 times, I called Susie and said that I didn't think it was done properly. Not that you're not going to change anything, I understand that, but your business comes from the realtors. And if you're not talking to the realtors before decisions are made to kind of get a feel of things, you're not doing it right.
I apologize if the message did not come across clearly.
It did
but
not
it was,
come across that way. I
well,
don't know
now
if
it's
you watched it.
it's clear though. But now it's clear. We did never voted or had any discussions about doing this to keep agents out of the room. The reason that they're not there is because of COVID. The only change we made is about funding. And that's a legal matter that our board and our committee discussed and decided. So I already have agents coming to my office. So I don't want you to think, nobody once said we're doing this to keep agents out of the closing process. That was never the case.
Well, it was certainly taken that way by, I talked to a lot of different agents and said, look, how do you feel about this? And they were feeling the same that I was feeling. So, because I wouldn't have said.
I'm sorry for that. I do
me.
apologize. That was not our intent.
Your presentation originally indicated that. And I'm not
I don't think it did, Leanne. I'll have to watch it again, but I did not get that. I watched the video presentation and I didn't get that interpretation.
Okay, enough said.
Leanne, I wonder, and John and Andrew, you made a point about realtors not knowing when sellers' closing documents have been signed. I don't know if there's any way to loop in the realtor so that they are copied on any of that kind of communication.
Yes, but again, we're I can't speak for other offices. There are still plenty of offices that, given their COVID policy, don't have agents, lenders. They're not allowed at closing. So I think that's more the issue, which is totally separate and apart from what we're talking about here. And again, I can't speak. I can't speak for others, but most of the attorneys on our committee all indicated that yes, while we'll keep the split closing once COVID's gone, if lenders and agents and brokers want to come, then that's perfectly fine.
Yeah, I mean,
Yeah,
I think.
Thank you for your question. I think you're representing the realtor piece of this really well. John, did you have anything else? Otherwise, we
Well,
can
I think that everybody, all the attorneys, well, not all the attorneys in our committee, but the vast majority of attorneys on our committee that do a large volume of residential real estate understand the relationships between the client, the realtor, the lawyer, and the lender. And all of them are sensitive to that in terms of, Leanne, I mean, you have relationships with your attorneys. They're sensitive to the fact that you send them business. We all appreciate the business that we get from realtors, and there's no intent, there was never an intent to somehow eliminate the participation in a way that would offend that relationship. That's not what this was all about. It was never about that. And the video that we did was intended just to explain the the manner in which funding happens now and the manner in which closings are taking place, and explaining why we got to where we got as it relates to the occupancy and funding issues. So, you know, please don't take that video, which was just Andrew and I trying to communicate a change in process, to infer in any way that we're discounting the relationships that exist between realtors and lawyers and realtors and their clients, and then in that whole triad thing there. So,
Thank you.
Henry.
Thank you for the background on this new manner of treating the funding. Bottom line, as a practical matter, how are we going to see this differently? Are funds going to be required to be wired sooner? And presumably
can't.
that
You can't.
Unfortunately,
Like
there's a
like John explained, and I think it's a good question, because I'm seeing a lot of the comments, people didn't even realize we had closing customs, which is a bit shocking to me. But the way the funding works is we're waiting on several things to happen. One is, the first thing is we actually get documents from the lender, which has gotten better lately, but sometimes you all can remember the days when we're sitting around at a 2 o'clock closing waiting for docs to show up. Then the buyer's got to sign. Then we have to submit those documents to the lender, along with some of the seller signed documents. So it assumes that we've received the overnight or the courier service giving us some seller documents, because the funding condition does require either the CD or the deed, or there might be a few other seller signed documents. Then we have to send that to the lender, wait for someone at the lender to review them and either tell us, yes, you're good, here's your funding number, or no, we need X, Y, and Z. And we have to receive the wire. So it's not as simple. What I tell my clients is, I still have a lot of work to do on the back end once you leave. So there's still a process. Some lenders don't require funding authorization. And they put the money in your account at 9 o'clock in the morning. And as soon as you sign, you're done and ready to go. Other lenders, it's more of a process. So it's really a case by case basis. It could happen quickly. It could happen not so quickly. And so we can't initiate that wire to go to the seller's attorney or to fund a payoff until all those things happen and we have a funding number. And at that point in time, even if it's before 6:30, my bank is not a 6:30 bank, but the chances of me late in the day initiating a wire, it clearing the Fed, as John explained, hitting another attorney's account on the same day, is the later it gets, the more difficult it becomes.
right. And if I can just add something, you know, some lenders, and Andrew said this, but it's really important, because lenders that require funding authorization, if we're closing a loan at 3 o'clock on a Friday afternoon, guess what? I mean, the chance of us being able to get funding authorization and getting a wire out is going to be very tenuous. You know, I'm lucky. I have a person who sits in post-closing, and her sole job when a file gets out of closing is to get documents to the lender, hound them for a funding authorization. But that's not every office. I mean, it's just not realistic. So, you know, there are lots of things that need to happen. Greg asked a question.
John, if we can hit back on one more thing on that, just to explain the process, I think it's good for people to understand. At the beginning, we get closing instructions from the lender that we sign saying, we're going to close this loan in accordance with your instructions. And if we don't, we're the ones that are on the hook. So there's a lot of money at stake, and we can't just take I know I've done closings for this lender a million times. I know I'll get funding authorization on Monday and send the wire out on Thursday, because we have either signed and our title companies issued a closing protection letter. There's a lot on the line on these individual transactions and a lot of money at stake.
You know, we both, Andrew and I both, have a lot of money in our client's funds account, but each transaction has to be viewed separately. So we account for each transaction. I need to be funded on that transaction before I can send out money on that transaction, even though there might be money in my account that's sufficient to accommodate that particular wire.
Yeah, I'm gonna throw a couple things at you guys and see what your response is. I think that the communication of the changes is, was good. I didn't take it the same way that the realtors were not included. I think that we have to communicate to our, if we can ideally avoid the Friday closings, obviously that's going to be an issue. But I have a multi-point question. The first thing, it seems like the back-to-back, or even worse, the back-to-back-to-back really starts to get complicated because
On a Friday.
Yeah, on a Friday at the end of the
Friday,
month.
very difficult.
Yeah, so you could be, if you're the third domino in a line and you're waiting for that first one. I mean, you guys are tying the tip is the it always used to be the release, and you had to get to the town halls, and some of these town halls have limited hours, and
That's gone away. The town hall issue is not an issue anymore.
It is not.
COVID has changed the way title insurance companies view this.
You're bonded over it.
In effect, there's gap insurance for recording.
Okay, so that answers that question. So we don't have to worry about that component because the presentation did not address.
Yeah, that's a good point, Greg. That's a good point as we continue to talk about this. Thanks for bringing that up.
Okay,
that is something we should.
So then we've got, and Linda and I were thinking the same thing. Section 16 of the P&S, which you guys both authored in the Conforms Committee, on the date and time of closing, the seller shall deliver full possession and occupancy of said premises to the buyer.
Right.
Now go read section 1. You can't read just one section.
Yeah, I mean, you have to read the whole
Section
contract.
1 says section 1 says you'll give me funds on the day of closing.
Right.
So they both have to happen.
Delivery of funds is a condition precedent to occupancy.
Okay. All right. So that still flies. It still makes sense. The handling, the question that we had too before I jumped on was, the communication from you as attorneys to let us know when it has happened would be super helpful because, my question about keys, if the keys are provided to the buyer, because they ultimately need the key. They need confirmation that you guys have been able to do the wire and the wire was completed, but we also then need physical keys. And are keys going to be able to be provided to buyers with express instructions to not re-enter the property until they've received the confirmation?
Yes. So one of the things we also have changed now when we're doing courier service to deliver seller documents, I before John, if he has a sale and I have a buy, before John sends me anything, I get a letter that is emailed to me that I have to sign, instructing me that I cannot deliver possession to my client until he receives funds from me. I sign it, I send it to him, he sends me the documents. Now, my buyer can have the keys in their pocket all they want, but they can't go in the house until John's office receives the funds. I don't think this changes any of how you're doing your walkthroughs or any of that part of it. I don't think this change really alters that.
The old way of doing it was we would leave, like Leanne said, we would leave the closing, the buyer would have the keys, you guys would head out the back door of your law offices, you would go and do your recording, the wire would happen, and by the time everybody went in their own paths, it was done,
Right.
For the most part.
Can I just say that while I sort of agree with Andrew, looking at things from the other side again, the day will happen when you've delivered keys to your clients with the express understanding that they will not occupy the property and they will move in. And on Monday, my seller will not have their funds and your client will be in there over the weekend, and my client will drive by and find out that your guy has been there over the weekend, and you, Greg, having delivered the keys, are the one that's going to get the heat.
Well, no, I'm saying that can it be from the attorney that at the closing that the keys be provided and the buyer sign to.
I'll tell you right now that first of all, at this point, we don't handle keys, right? In virtually no transactions do we handle keys the way things have been handled with COVID. If the answer is now that I, as an attorney, am going to be responsible for keys are going to remain in my possession until I have authorization from the seller to release keys. Do you agree with that, Andrew, or disagree?
Yes, like if you overnight me docs with a key in it, I wouldn't give it to them until you had your money.
I'd like to.
So what are we supposed to do as agents with the keys?
Really, what I've seen more often than not, if there's a lockbox on the property, you say, is there a lockbox on the property? And they say yes. And then you say, well, once I'm funded, you talk with your buyer agent about getting you a key out of that lockbox and have the seller leave the rest of the keys inside the house.
I would like to weigh in here a little bit, if I may.
Come on.
Yes,
Bring it
Amy,
on.
go ahead.
So I think that from my experience over 31 years in this business, I like to boil things down to my practical reality. As a realtor who serves my clients, I love to maintain the best relationships I can with all the parties, of course. That includes the attorneys and the lenders and, of course, my clients. Here's the thing. We have always seen buyers with moving trucks headed towards a property 3 hours before closing, and the disaster happens when the truck wants to drop stuff off or keep it for another 2 weeks. And we've got a delay or something. So I think that my takeaway is we need to change the way we counsel. Not that we're legal counsel, but practical counsel. Until the funding occurs, maybe you better line up that moving truck for a day or two after. And since there's only 27 agents on this call, we need to figure out a way to get the word out of what it is we need to do. Because I can only imagine how many hours I'm going to spend when I'd really rather be in bed in the evening with some agent who wants to pull their hair out because they didn't know the keys were not going to be delivered. Not a good point?
Yeah, and that's a great point that we do need to educate the buyers and establish those expectations, because quite frankly, if we just let them, they don't get to call the shots. They sign a legal document saying it's the customs. Well, they don't even know them. We need to educate them. John, is there any way for you to identify these lenders that are difficult, these lenders that are the back end that are mucking up the works? Because seriously, if I can tell my buyer up front, hey, by the way, that lender that you want to use, no problem, you can use them, but just be prepared to be in a hotel for a couple of days.
Let's stay away from anything related to antitrust, please.
But thanks for asking.
But even the best lenders you're going to have a problem if you're closing at 4 o'clock on a Friday. Like it's not necessarily the lenders not getting it done. It's just a process that takes time. And some lenders don't require it. Other lenders do.
You know, can I just say?
Can I ask a question?
Just give me just 1 second.
Okay.
I don't know who's talking, but the other thing that you have to realize as a group is that there are numerous different closing agencies, law firms, right? So I have a staff of 11. Andrew's all by himself. So those are the two good ones, right? Because he does everything in his office, and I have a lot of people to do my stuff. But there's a whole bunch of stuff in the middle where, somebody's got a single paralegal, and it's 4 o'clock Friday afternoon, and a closing is taking place in one room, and they're working on post-closing stuff in another room, and then they have to get a wire out someplace else. So it's not just the lender, right? It's the lender, it's the settlement service provider, the attorney office, it's the perspective of the client, the seller having as important a perspective as the buyer, right? The buyer wants to get in, but the seller wants their money. So it's a confluence of events. It's not just the lender, right? It's not just the lender. The vast majority of lenders, national lenders, require funding authorization with documents going out. I'd say maybe 30% of our lenders do not require funding authorization. And that's just one piece of getting the money to the next place.
So this is what
Sorry.
can I ask you a question? This is what I'm going to take away from all this is I'm going to counsel, like Jeannie said, our job is to counsel our people. I'm going to counsel them and I'm going to say, you know, this is when we're supposed to close. We're scheduled to close, but why don't you not, you know, put 2 days in the kitty for any problems, and the seller's attorney will determine when you can move in. And I'm going to pass the bullet, dodge the bullet, and I'm going to blame. I'm not going to blame. I'm going to ask for the attorney's graces when we can get in. That way I'm not on the hook for bad information. Because it's up to you guys to tell us when we can go, our people can go. And if we just say all that, then maybe they can get that hotel room, or they'll know about it and they won't freak out when it happens.
So,
Well, I think
so John, to add to that,
communication, just 1 second, Andrea. Communication is the key, right? So when I teach contracts or when I teach orientation, one of the things that I talk about with the people that I'm trying to educate is that dates in contracts are not written in stone, right? They are not written in stone. They are written in sand, right? They can be brushed over and changed. So whether it's your closing happening on a particular day or a mortgage contingency happening on a particular day, it's important that you as a realtor communicate with both sides. Like the seller needs to know that it might not happen on the closing day. So it's all about communication. And I agree with you 100%. I 100% of what you said. Andrea, I'm sorry.
that's okay. So are we to assume, I keep hearing Friday. Is this scenario you're thinking is only going to happen if we close on a Friday, but if it's a Monday, Tuesday, Wednesday, Thursday?
No, it's just a longer delay if it's Friday, because then you got to wait till Monday.
Right.
So it's really any
Right, that's the
late.
issue.
If it's 4 o'clock on a Thursday, you're not getting possession until Friday. It's just, we
Was there
say,
a discussion about
what-
not having late afternoon closing?
if you don't want us to close half of our closings, sure. Like there's only so,
Right.
you know,
There's only so many time slots in the day.
Yeah.
So Andrew,
Right,
so basically, if they close on a Thursday at 4 o'clock,
they're probably not getting occupancy. And if
Right.
there's a specific issue that specific transaction requires the buyer to get occupancy on Thursday, then that's something we need to know in advance and the parties can discuss. And like I said, depending on who the players are and what
Right.
actually happens, maybe an arrangement can be worked out.
but otherwise it could be Friday, sometime Friday, we're passing the keys to them.
Yes.
And let
Okay.
me just say that, you know, the communication and the agreement to deliver, to allow occupancy can be discussed with you, by you guys. So, you know, if you're representing a seller and you're discussing with the buyer's agent occupancy issues, that can be discussed by you guys and agreed to, and we'll abide by it for the most part. I mean, there are a lot of attorneys out there, though. If it gets to us, if it gets back to the attorney, and the issue is, I'm talking to my seller client about occupancy, the answer is, from most attorneys, a blanket no.
John, one thing to clarify on that, though, the blanket no is, we want to close a week early. We don't have full commitment. We don't have clear to close. We don't. That's
Can we
the
move
blanket,
in?
right? Like, but this one is, we closed. You have the wire. You have the funds. It's a little bit less of a risk than our default. No.
100%. But I could name, I won't, but I could.
Yes, I could
name
too.
a few attorneys that, you know, are going to go right down the path, right down the path. There's going to be no deviation from it. So giving them the opportunity to get their nose involved will lead to a particular answer.
So my takeaway seems to be that we do our walkthrough ASAP as soon as the properties, and John, you've always said, do it, don't wait for an hour before. You'd like to know about the issues if there are any, right?
Right. So my issue with that is repair, inspections after repairs.
Right.
It drives me up the wall.
Correct.
Right.
But we could have a whole conference about how we handle as a group, how we handle repair issues. That would be a whole another hour, easy.
I
Right,
believe
but-
Joe Simmons had a comment about that. Joe, do you want to go ahead and expand on your comment?
I'll finish while Joe comes back to us. So the thing about, we as agents, best practice sounds like do your walkthrough as soon as possible, 1. 2, plan on going back to get your lockbox when you're the listing agent, because you're going to leave it on there with the keys in it until funding is there. Is that sounds like the best practice, correct?
It doesn't work for electronic lockboxes, right?
No, that's not good, because we now have to do 2 walkthroughs the way I see it. 1 early to help the attorneys. I totally agree with that for the inspections. And 1 just before closing is supposed to happen, because what if they take out the copper piping that night? What if the house gets vandalized?
Yes, yes.
Yeah.
Yeah, to clarify that, I think that the final walkthrough should be done as close to closing as possible.
Right.
And what John's hinting at, and we've talked about this, is there's repair work done that was done a week ago, and you waited until the final walkthrough to go make sure it was done, and then you call us and say, hey, the electrical panel wasn't replaced. So
in
that's
the closing customs document, does it speak to what you attorneys refer to out of the 25 pages, the reasonable time? I've heard that phrase, reasonable period of time.
That's more case law, judicial interpretation than anything else of the lack of the use of the term time is of the essence.
The absence of time is of the essence. And we've got a closing date, which some buyers will in their brain say, well, it's just like a flight ticket, right? It's the plane's taken off.
Yeah, but the plane gets delayed.
Exactly.
Flight gets delayed.
The best way I've heard it put is the closing date, it's like a due date, and you could deliver it early and you could be late.
That's true.
But what do you guys have for framework that we can communicate to our clients on this in terms of delays with, and it could be mortgage commitment? What do you, best practices you want to see us always get extensions? What do you want?
Absolutely. That's absolutely, extensions are best practice. There's no doubt about it. Relying on the fact that the law implies a reasonable period of time for contract performance is not the way to go if you can get an extension. But
okay,
realistically, I get these
John,
phone calls. What?
But by getting an extension, you just kicked out the reasonable time period. So you got to be careful with the
on the
extension.
other side.
Right. So if I'm the seller and the buyer asks me for an extension, the closing date, we're 2 weeks past the closing, and whether the reasonable time is 30 days, whatever it is, you just reset the clock on the reasonable time.
Right. That's correct. But here's the thing, I have this conversation at least once or twice a week with clients who are upset that things aren't happening when they're supposed to happen, or that a seller doesn't want to sell, or that a buyer doesn't want to buy. As good as Andrew is at what he does, he cannot drag a client kicking and screaming into a room and make them sign documents. He cannot drag them into a room kicking and screaming with a check to buy the property. So what it comes down to is we either negotiate this stuff in every circumstance, or we refer someone to a litigator. That's really what it comes down to. The contract is only as good as the people that are standing behind it. Because a buyer doesn't want to buy this property 2.5 years down the road after they've sued the seller, and the seller doesn't want to sell this property and the seller doesn't want to get sued. But that doesn't happen much in our area. So it's all about negotiation and setting expectations.
We have a statement from Linda Barrett, or a question. Could the attorneys have a hold harmless form that allows a buyer occupancy until funded to not make the agent liable?
Well, we all have a hold harmless form. But that would certainly resolve the issue, but it would not solve the problem, right? It would not solve the problem of my seller client getting their money.
Right.
Right. And if we're going to have this be our default provision, for us to have a default hold harmless to get around it, defeats the purpose. But I think on a case-by-case basis, we obviously can have some input. And getting back to what John said, if you as the agents and brokers know of a reason why this is going to be a significant issue for your buyer, and you talk with the other side and they come to an agreement, do that first on the broker or agent level, and then come to us
and say,
it's going to be a lot easier than you calling us up and saying, hey, will you call the other attorney and ask us if we can get in before we're funded? Because the answer will be no.
Well,
and in that circumstance, we can prepare a early occupancy agreement or whatever it is that we're going to use in that circumstance.
But can I ask
Henry?
another question? I'm sorry to keep
Sure.
talking. So let's say let's be real here. And we have a family moving in from, military family, whoever, moving in from out of the area by quite a bit, Hawaii, say. We do that a lot. Now, could there be something that they sign that, let's say everybody agrees on early, they can get in even though the funds aren't quite cleared. Can they sign off on something that you guys have created saying, if it doesn't work out, they'd get their stuff out of the garage, say. Just say the garage, not the whole house. Okay, you can move 17 boxes into the garage. Sometimes you have to be able to do the garage thing. The garage thing is easy. You can, worst case scenario, us agents lug it all to who knows where. I don't know. Realistically, people have to move in sometimes, someplace on the property.
Yeah, and I think, John, we'd have to really, if we would use the same, one of the customs in here that references also the use and occupancy. We have a standard use and occupancy agreement that we use for early or late occupancy if a seller's staying. And I don't know, John, we'd have to figure out in that situation where the parties agree what we were going to use, if we would use that same use and occupancy agreement we're using now. That's probably something we need to think
We're
about.
talking about no occupancy just for possessions.
Or
Yeah,
probably
in the
some
garage. Okay.
Yeah, I mean,
probably some different levels
Use a
of
hold
that.
harmless. Right.
Yeah.
Right.
Henry, did
And
you have
yes.
one more question? We're right at 10:01 here.
All right,
Wrapping up.
A lot of great points covered. I agree with Robin and Jeannie and just trying to get down to practical elements. The lockbox for delivering keys, I think makes sense, but you still have the buyers who are oftentimes in more of a crunch than the sellers. And, there are factors here which are out of their control in terms of documents moving back and forth, which have a direct, significant impact on their, how they're going to be living their lives here in the near term. And you've got the issue with the moving trucks, I'm here for the next 12 hours and then I'm gone. And I'm still not clear that we've got a satisfactory resolution to these points.
I think we can come up with some best practices to send out to you guys, and rest assured that the rest of the state has not blown apart with the closings and buying and selling of homes. So I think it's not as much of a crisis as it may feel at this very moment. But this was a good conversation, and I think it is time to wrap up. And thank you guys so much for
Thank you.
coming
Thank
on.
you very much.
Thank you.
Welcome.
Any other questions you have, if they did not get answered, please send them to me, and we will put together best practices for you and send it out. Thank you, John. Thank you, Andrew. Thanks to everybody.
Have a good day, everybody.
Thank you, Bonnie.
Thank you.
And everybody have a great day.
Bye, guys.
Thank you.
Thank you.
Bye.